First District Court of Appeals now in session. All who have business before this court draw near, give attention, ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Welcome, everyone, to this afternoon oral argument in case number 24-1055, L. Anton Rebuttal versus John Gillis, Head Industries, and Amerisure Insurance. Appellant, when you're ready, you may begin. Maybe let me know how much time you would like to reserve for rebuttal. And maybe unmute yourself.
My apologies.
Very good, thank you.
Good afternoon, Lee Rebuttal, pro se for the appellant. Initially, 8 minutes with the remainder for rebuttal, if it pleases the court.
Okay, you want 12 minutes for rebuttal?
Yes, sir, if possible.
Okay, thank you.
First, I want to thank the court for the afternoon time accommodation. My vocal cords are weak, but I promise the court my best effort. I begin by addressing the fundamental final appeal issue raised by Appellees. Appellant submits that the appeal order terminating his retainer agreement, and with it canceling all forward-looking rights to fees and lien protections previously in place, are clearly severable from any hypothetical future fee amount hearing JCC previously acknowledged is not ripe for adjudication. Accordingly, it fundamentally appears as if there are no further JCC labor activities required relative to the appealed issues. Had I opted not to appeal this order, that probably would have been risky. Additionally,
if I can jump in and just get some clarification on some of the facts, please. So it looks like the last time that you were awarded a fee, and correct me if I'm wrong, was March of 2015. It looks like you filed an attorney's fee data sheet, and there was an order on a joint stip resolving that fee. Is that correct?
Yes, ma'am.
All right, and so no further petitions for benefits were filed by you on behalf of the claimant after that, correct?
I believe that's what the record reflects.
All right, so the lien issue that I'm assuming is your greatest concern, obviously, based on the briefing. So the lien that you are trying to carefully preserve, I assume your argument is, I want that lien viable in the event the case settles in the future. Am I correct on that?
Among other concerns, on an ongoing basis, I am left without the benefit of being a secured creditor, so to speak.
Well, but you have a trust account from taking X% of the claimant's compensation checks that went on for what, 20-something years, so you still have a trust account that you haven't drawn on in how many years?
Many, many years, decades. It's just a reserve that's sitting there. My ultimate hope is that I will be able, one way or another, to secure fees for the carrier so that all might ultimately go back to the claimant. That would be the ideal situation.
Right. Well, I don't want to get ahead of ourselves because I think that may be issues for the future or for, the claimant's current attorneys. But as we sit here today, though, your number one concern is viability of your lien, period, and the statement from the judge that your retainer agreement has no further force and effect, correct?
Right, that's definitely a final decision on her part. That won't be revisited, but for this appeal.
And I expect that Mr. Rogner is going to argue that there's a jurisdictional problem here. Why is this a, quote, final order that provides us with jurisdiction? Can you address that, please?
Yes, ma'am. Thank you. I think that's an important question. Ultimately, a fee hearing may or may not occur. That fee issue might be resolved. We could go to mediation. It is never heard. But in any event, there's no filing that's currently before the JCC that addresses that issue. Nobody has asked for that. So that there is no further business for the JCC to attend to at this juncture. The other thing that I would bring to the court's attention is that we know that by nature of 440 proceedings, it is a piecemeal focused litigation process. So that discrete aspects of a JCC order, even while the broader workers' compensation case remains open and ongoing, is still appealable as long as it addresses a discrete matter. The parallel concept would be in civil cases. You might have an order that is final for some purposes, but not final for other purposes. And with respect to those aspects that are discrete and severable from the non-final issues, those are properly appealable. So that would be the analogy that I would offer to the court. There's also the aspect of irreparable harm factor, because as the indemnity payments continue to be paid out without having in place any vested lien protections that appellant contends are part of his contract and part of a 1993 fee order that is integrated together as an integrated document with that fee order, is now being vitiated by a subsequent JCC who has no jurisdiction to impact that prior order. As time goes by and checks are being paid out, I'm not putting those in my IOTA account as a secured creditor, notwithstanding the fact that it was my legal efforts that triggered the creation of that raise. So that's somewhat of an irreparable harm factor. The more time that goes by, the larger that amount of money represents. If the claimant has a life expectancy of 20 years, they could add up to a substantial sum.
Well, and let's go to, I mean, to me, really twofold for this order that's under review, two statements. One, that your retainer agreement no longer has force and effect. Do you, a contractual interpretation perhaps, but when I'm looking at the retainer agreement, I read it as saying that you have entitlement or you're claiming entitlement or a lien to fees, whether you currently represent the claimant or not, based on, I assume, the PT status that you acquired. So am I interpreting your retainer agreement correctly, that it has distinct language in there that says I don't have to be currently representing the claimant to claim entitlement to a fee?
Yes, ma'am, you're precisely correct. That is my position.
Also, is there any provision, I don't see it, but is there any provision in your retainer agreement that says you are only claiming a lien to fees, quote, during your representation, close quotes?
No, I think that is not a fair representation of the contract terms, because the contract terms specifically say that should the claimant, my client, previous client, discharge me, it has no impact on my contingency fee rights. So that would be the Polestar provision in the agreement that I would attach to the significance of your question.
And with regard to finality on a jurisdictional perspective, would those two arguments be your main arguments with respect to why this court has jurisdiction over this order as being a final order, because it makes those two conclusions?
Right, and in my humble opinion, I think the JCC departed from the essential requirements of the law. There are many cases cited in the initial brief that speak to an inability of the judiciary to interfere with contract rights. There are specific cases cited in the brief. that involve workers' compensation cases.
And why
So
wouldn't we wait to wrestle with all of these issues until there's actually some compensation that needs to be distributed? I guess that's what I'm not getting, that here and for a decade it sounds like there's been nothing to distribute, and so you've got a pool of money and you've got things going on with the potential for future distributions, but nothing has come to a head yet. Why don't we deal with it then?
because as time goes by, and my humble 15% percentage that I'm contractually entitled to is not being protected. It's not going into any IOTA account, which is what the 1993 order requires. Instead, it is simply going to the claimant directly, who has no incentive at all to put that 15% aside as security for the prospective future-looking percentages that I am entitled to as a matter of contract. That's my benefit of the bargain. It doesn't end upon discharge or any other conditions. It simply goes on. And I think that's to both the claimant's best interest and my interest, because it creates a larger pool of fees against which I can balance ultimately return to the claimant, depending upon circumstances and negotiations with the carrier. I've been doing this for almost 40 years, and this method has been most beneficial that I can see shared fairly between my client and myself. I think that what we're focusing on in this appeal is the sanctity of the contract. Do we honor the contract, as I believe a collection of first ECA cases in the workers' compensation context require, or do we depart from that precedent?
Mr. Rebuttal, you're under your rebuttal time, so you may continue, or you may wait and reserve your time for rebuttal.
Your Honor, if anybody from the bench has questions, I think my best use of time is to try to answer those questions.
Thank you. Mr. Ragnar.
Thank you, Judge. May it please the court. My name is Bill Ragnar. I represent the employer carrier in this case. And stated briefly, Your Honors, this case at its core is a fee dispute. And we believe the order is non-final. The court lacks jurisdiction to review it because it does not end judicial labor over the fee issue, which is the sole basis of the dispute. The order expressly reserves jurisdiction over Mr. Revalco's fees, including fees related to sums that he's been collecting for 3 decades.
Mr. Ragnar, if I could just
Sure.
Cut you off there, and hopefully we can get some specifics here. And that, to me, the valuable argument here is, preservation of the lien, if in fact he's due any more fees at all, which is not, necessarily why we're here today. But when I'm looking at a July 11th, 2023 order from the same judge. It was an order granting substitution of counsel, denying request for judicial determination of entitlement. So we're talking about within a couple of 6 months or so. And in this July order, Judge Forte reserves the lien, and it uses the language, retains a lien fee for attorney's fees and costs. Determination as to entitlement is not ripe for review. Yet the order that's been appealed today uses much more specific language. It actually says the retainer agreement is terminated and has no further force and effect. That's terminating the contract, and that's that's far and beyond saying I acknowledge a lien. And for the lien purposes here, the judge further says the lien for attorney's fees and costs during his representation. So the judge goes much further in this order on appeal than she had in the previous order, and I mean, I certainly can see Mr. Rebalco's concern with respect to viability of retaining his lien, whether he's due a fee or not. But why do we have this additional language here, and that's separate and apart from a prior order from the same judge?
Well, I can't speak for the judge, and I didn't draft the order, and I don't know why the judge chose that specific language.
Speculate for me. You know what question I'm asking you.
Well, what I see is in the aggregate, or stated simply, she has preserved the fee lien in both orders. The language is different. But, all right, so the claimant, any client has the absolute right to terminate a lawyer. And I think what she's saying is you're not the lawyer anymore. You're not his lawyer anymore. You've been terminated by your client.
I can understand that, but going so far as to say your fee retainer agreement no longer has force and effect.
Well, again, I can't step into the mind of the judge, but the way I read that
Well,
was,
isn't that a reason to remand and get some clarification, perhaps?
well, I was thinking about this, Judge Thomas, before this argument. This is a very unusual situation for me because, normally I've got, Mr. Weiner or somebody on the other side that's representing the injured worker. And I've got a fee motion pending. And I think, well, if this thing gets remanded, my client's going to pay a big fat fee to Mr. Weiner. That's not what I want to happen. In this case, if the court wanted additional findings or clarification, I don't have any problem with that at all. Because, the way I look at it right now, let's say you dismiss it on jurisdiction, or even if you reverse. If you don't say, we reverse and the employer carrier is hereby directed to issue the checks payable to Mr. Rebalco, then my client's going to keep doing what they've always done, or what they've been doing since the new lawyer and the new guardian took over, which was we're going to issue the payments to the guardian, just like the judge ordered us to. And Mr. Rebalco is going to be in the position where he's going to have to do what I don't understand why he hasn't done, which is file a verified motion and seek his fees. Judge Thomas, that retainer agreement, that order approving the retainer agreement, it does not say that money is his. It doesn't say it's his fee.
And I'm not arguing with you there. And I'm sorry, I don't have, also, with respect to how the checks are going to be made payable, I don't think there's merit to the argument for Mr. Rebalco that his name has to remain on the checks. No, I have no problem with that. My issue and my questions to both of you, at least from my perspective, is I think there's merit to his argument that I just want to make sure that my lien is viable, that it's not being extinguished, because obviously you're not the attorney who's going to argue against splitting a fee with him. It's a third party not present with us today.
Right. And I think, Judge Thomas, that goes back to Judge Osterhaus's statement, which addresses finality. I look at it as Mr. Rebalco has not been harmed yet. He's not been harmed until the judge says, till the lower tribunal says, because I found your retainer agreement is in no force and effect, I'm going to make this happen to you, or you're not going to get paid, or you're not going to collect this money. When the judge does that, we take it from a hypothetical injury into a concrete injury, which is why it goes back to my central point, which is this is not a final order. The judge has said, look, you've got your lien, come back and pursue your lien, and you can either get paid or not get paid. And then if he suffers harm, then we reach the point where we're getting to finality, where the judicial labor is ending over the core dispute, which addresses nothing other than Mr. Rebalco's fees. So right now you are articulating, and I don't think you're wrong, Judge, you are articulating.
Thank you.
Well, I didn't mean it that way, but I think you are articulating a valid point that there may be concern that there may be harm in the future, but I don't think that the harm has been actualized.
Well, I try to have valid points whenever possible, but you cannot sit here today and speak on behalf of another attorney who represents the claimant, who would say, I'm never going to raise the argument that you should have appealed that order because the order said your contract had no force and effect and your claim for fees was only during your representation, And so you have now waived any argument against that declaratory statement. And I know that doesn't bother you personally based on who you represent, but certainly you can predict the potential profound effect by the claimant's current attorneys who may have to apportion fees with Mr. Rebalco. So, you know, I dare say that those statements by the judge, there's finality in those statements. There's ramifications in those statements. I mean, are you disputing that?
No, your point is well taken, Judge. Now, Your Honors, the Mr. Rebalco has raised 10 separate points on appeal, and rather than me addressing each one of them individually, I would prefer to simply invite the court to invite the court's questions on anything that you would like me to address. Then, Your Honors, our position remains the same. We do not believe this is a final order, and we think the court should dismiss the appeal for a lack of jurisdiction. Thank you.
Thank you, Mr. Wagner. Mr. Rebalco.
Yes, I think that we were right on point with respect to the colloquy between Mr. Wagner and the court, which essentially saw the appellees attempting to rewrite the language of the JCC's order. The JCC order says what it says, and that is exactly the way at least one member of the bench has articulated it to be. I do think that all 10 points on appeal, whether considered jointly or severally, are valid grounds for reversal. And I consider that the answer brief does take some liberty with the record on appeal, the facts set forth in the record, and the interpretation of case law. And in carefully writing my reply brief, I attempted to address that liberality head on. And I believe that under scrutiny, the answer brief does not withstand certain basic criticisms in terms of how the cases are somewhat conflated to reach a goal. I view that as zealous advocacy, and I'm certainly not faulting opposing counsel for being a zealous advocate. I think he did a very good job myself. I've known him for years. I know him to be an excellent lawyer. So I say that despite the fact that in the broader context, I view him with a great deal of respect, with a plethora of knowledge in this area of the law. But nonetheless, I do think the issues that I raised with respect to, for example, the JCC somewhat stepping into the adversarial ring, which is not her role as a neutral and detached entity, by raising issues that were never raised in the motion that she was directing her order to. These were issues that she, sua sponte, raised herself, which I think was beyond her authority and jurisdiction to do. There are many cases cited among both of my briefs that speak to that issue. Due process is a major part of this appeal, because when all is said and done, it is clear to me that my word, not a single word for me, was ever considered in this order. It just never was. And considering how it impacted both my property rights and my contract rights, depriving me of any opportunity to be heard before rendering these final orders was inconsistent with constitutional protections. These are the reasons.
Go ahead, Mr. Rebalco.
these are the reasons that I offer as legitimate grounds for reversal. Thank you.
Thank you very much, and thank both of you for your arguments. That concludes our session for today. We are adjourned.
Thank you. Thank you, sir. Thank you.